Friends, today we have got a judgment of Supreme Court on DV. Friends, many of us have their cases running on, of especially of matrimonial disputes, of 498A, of DV, divorce, etc. In this judgment, court dismissed the appeal of wife and gave a judgment in favor of husband, dismissing the right of the residing rights and the maintenance rights of wife. It rejected to give maintenance and residing rights to wife. This judgment is very helpful to those who are facing false cases of DV and they are tired of fighting such false cases. You can use this judgment if conditions of your case are similar to this case. So friends, let's discuss what this case was about. Friends, first of all, I would like to tell you the difference between the maintenance asked by wife in 125 CRPC and maintenance asked in this DV Act. Friends, a wife can always ask for maintenance under section 125 CRPC, that's her right. But she can ask maintenance in DV if and only if domestic violence has been done to her, some type of mental or physical cruelty has been done to her, then only she can ask for residing rights and for maintenance, whatever relief is there in the DV Act, she can ask for those relief in DV Act only when she has been tortured by her in-laws. So now friends, in this case, wife filed a false DV case against her in-laws, against her husband, her mother-in-law, her father-in-law and her sister-in-law. She involved all these people in this false DV case, asking for residing right in her sharehold house, and she also asked for maintenance for her and for her daughter. Now in this case, magistrate rejected her case as she was unable to prove her point. Now she went to appeal in district judge. District judge accepted her appeal and put a maintenance order of 2500 to wife per month and 4000 rupees per month as maintenance to her daughter. Now husband went to High Court in its appeal and he gave all the evidences, and by listening to both the parties, it also reviewed the judgments of lower courts, and it finally saw that wife was unable to prove that the incident of torture, it happened when and how did it happen, or demand for dowry, or any case of or any incident of physical torture or mental torture, any type of torture. She was unable to prove any of these. So in the light of all these things, her maintenance was rejected. Her right of residence was also rejected. Husband's appeal was accepted and it set aside the order of the lower court. High Court said that maintenance under DV, residing rights and all, can only be given when domestic violence has been done, when any type of physical or mental cruelty has been done to wife. If it is not so, then she cannot ask, because she is a wife. She cannot ask maintenance under DV. For that, she will have to go under 125 CRPC. But she can't ask that for in DV. Friends, we have this misconception that wife can ask maintenance in 125 CRPC also and in DV also. She will get it for sure. But it is not so. DV, by its name, it signifies domestic violence. If it is not there, then DV case can be dismissed and you can be freed of giving maintenance to wife. Now when High Court gave its judgment in the favor of husband, wife went to Supreme Court in its appeal. Court also saw the same thing as High Court saw, and it said the same thing, that if no cruelty has been done, then no maintenance and no residing rights will be given to wife under DV Act. But it also said that it doesn't mean that maintenance to a daughter will be cancelled. It will not be cancelled. Maintenance to daughter, which was fixed 4000 rupees per month, it will be given in any case. So here Supreme Court dismissed the case of DV. Friends, it can be very helpful if you are also facing false case of DV. For your help, I will give the link of this judgment in the description box. We will meet in next video. Till then, bye bye, take care and thank you for watching.